SJC-11788, Commonwealth versus Matthew Trayler.
Thank you. It's been very uneasy. Trailer.
Mr. Hirsch, good morning.
Good morning. If it please the court, Mr. Chief Justice, David Hirsch representing Mr. Trayler. In the case below, the appeals court, by making a rule of one crime per injury incurred under Statute 265, Section 13J, has come up with a new rule that has no basis in the statute, that's contradicted by case law, and has no basis in logic. Let me give you an example. Suppose I were to punch somebody in the mouth. This person suffers the loss of a tooth. Obviously, that's one crime. Suppose, though, as a result of the same punch, this person also suffers a split lip. Has my one punch suddenly become two crimes? I don't think anyone would say that.
No, but oh, okay. So, but if you punched somebody in the mouth, and you simultaneously or almost simultaneously, ripped their arm out of their socket, or hit them very hard in the stomach. So you've got two assault and batteries there, right?
Not necessarily. Under Commonwealth versus Miller, there's only one crime, even if the different injuries are caused, one, by hitting with a hand, and two, by hitting with a hammer. It's still just one crime, same incident, under the Vick standard, which should be the controlling standard in this case.
So the briefs seem to focus on act versus injury.
Yes.
It's really episode versus injury, I take it. Because you could punch somebody multiple times, kick them, and do all kinds of things.
I think
within 20 seconds.
Under the 20-second rule, I think Miller would control, and it would only be one crime. I'm not completely confident in saying that it's always just one crime.
Why not?
Because
well, give me an example of where it wouldn't be.
Excuse me. There are cases involving assaults where there's been more than one act in quick succession, and the courts have found multiple assaults. I don't know how to reconcile.
It happens in indecent assault and battery quite frequently, doesn't it? I mean, in other words, you have different kinds of indecent assaults and batteries happening, all part of one transaction, and you get different counts?
I think, Your Honor, you just cleared up the matter for me, because the issue is really whether one act is necessary to the completion of the other. So if, say, there have been rape cases where there has been, say, what might be considered an indecent assault, a touching of an intimate body part, but it's not something that can be considered an act separate from the rape itself.
But what about if it can be?
I'm sorry?
What if it can be? In other words, you have a touching of the breast and also a rape.
If they occur at the same time, there is case law saying, or say using Justice Spina's 22nd rule, there is case law saying, no, that's only one crime.
But there's also case law saying that those are two crimes.
Well, again, I would think that would One is whether one act is necessary to the other, is included in the other. But I think we're getting a little away from the main issue here, and it's my fault because the key here is not whether two separate acts can constitute one crime. Yes, that is a point, but it's not the important one in this case. Our point is that the appeals court has gone far beyond that by saying that there's only that if there's that situation in which I punch somebody in the mouth, the split lip, the lost tooth, that's 2 assaults, even with one act. No.
Can't the legislature do that, though?
If the legislature were to pass a statute explicitly saying that's what happens, that would pass the Vic rule. But that's the whole point of Vic. It doesn't happen unless the legislator explicitly states that's what we intend to do. And they certainly haven't done that here.
Now, what is at issue here appears to be not what he did, but what he purportedly, or what the jury found he failed to do, where he had the duty to act. So how do we deal with an act-based crime where the crime is the failure to act?
That leads to, and that's another issue in this case, Your Honor. How many times can one fail to intervene, can one fail to prevent in the course of a single incident? So taking the question Justice Botsford asked me, if you have the punch and the kick, has the person who allows this to happen committed 2 crimes by sitting there during that 20 seconds, that 30 seconds?
Why not?
Because the
One
legislature...
punch, one kick, next punch, next kick. Why isn't each of those a failure to prevent?
Because a failure, we have to discuss whether a failure to prevent...
It's really a failure to prevent the injuries, right?
Well, the failure to prevent is the act, I would say, and the series of acts. And if you sit there while somebody punches someone 20 times, kicks someone, is that one failure or is that 2? If it's in a short period of time. I'd suggest, again, under Vic, that's a legislative determination, and the legislature hasn't made it. Therefore, the rule of lenity applies.
So in this case, if you have Dr. Newton saying, X injury and Y injury, in my opinion, happened at different times, is that 2 offenses?
Well, yes, because first of all, in this case, there are 2 different ways in which that applies. First, nobody doubts that, as Dr. Newton said, there were at least 2 incidents, at least 2 acts causing these various injuries. On the one hand, you have the older series of rib injuries, I think 14 of 17, if I remember, 13 of 17, which everybody agrees are separate, and that's why I've stated in the brief that there's no doubt that there can be a maximum of 2 convictions in this case. But what happens... What the appeals court has done to take this further, they've said, well, it's possible that there were more than 2 acts, based on the fact that Dr. Newton says, I can't be sure they happened at the same time, although I think they did.
I'm sorry, the second act was the first is the rib injury, so a blow to the chest, and the second...
Those are the ones that had callus on them, right?
Right.
Okay.
You're really saying episodes involving several episodes. Are you going back to your original construct of episodes? So you're not. You really want to say act?
Well, again, I think I think this court should establish different rules for permitting something to happen and for doing something in this context, because if you're sitting there, you are not permitting twice. But in the case of, let's say I'm wrong on that, and that this court is going to say, as many acts as there are in an episode, you can have that many convictions, even though the legislature has not stated that explicitly. Let's say it's acts. We do not have, there is no proof in the record by which even under a preponderance standard, a reasonable juror could have found more than 2 acts here. Now, we have the argument that there are different mechanisms of injury. One requires the pushing of the leg, one requires the twisting of the leg. But let's say that there's one act that through, say, a throwing or a swinging, or I think the term used by Dr. Newton was jerking.
The arm.
Yeah, in the cause of that jerking, the child hits the floor with great force. Has one crime now become several because that jerking has also caused the injuries to the spleen, to the liver, to the 3 other ribs, caused the bruising? We have no evidence to say that that has not happened, that that is not what happened. Taking my original analogy, what happens?
Well, isn't that precisely why the legislature may have wanted to punish the injuries, the causing of the injuries? Because you can't tell. Was he hit 5 times during the course of a single day?
As Justice...
And what is the interest being protected here? It's children being protected from injuries, right?
And you can define injuries either as counting each one or injuries as a unit of prosecution.
But you can go both ways.
But there we end up with the rule of lenity and Vic. What if the legislature meant?
How is it the rule of lenity if we conclude that the legislature intended that this is an injury unit?
Because Vic says that doesn't happen unless the unless the legislature explicitly says that's what we intend, and they haven't explicitly said that here.
What's being punished? Is it an assault and battery, or is it the injury?
The assault and battery. Now,
It's allowing it to happen in your case.
I'm sorry?
It's allowing it to happen.
Yes, allowing the assault and injury to happen, and battery to happen in this case. Now, the appeals court talked about staircasing, how the fact that we have the difference between bodily injury and substantial bodily injury indicates that the legislature intended that that we go by the injury rather than the act. But that's contrary to what happened in the Gordon case, where this court said, I'm sorry, I don't remember which court said that staircasing of penalties affects only the severity of the sentence for the single crime. It doesn't make it multiple crimes. Going back to my original...
If I can turn your attention to for one moment. You, in your brief, say 2 things. One is he should not be found guilty of as many crimes as he was found guilty of. And you say then, but at the very least, he should be found guilty of no more than 2 crimes.
Correct.
But then you go on to argue that there's not sufficient evidence. I assume you also contend that there's not sufficient evidence to convict him of any crimes.
Well, yes, but the court didn't grant me review on that issue. I would love to argue that issue.
Okay. So that issue is not before us.
Correct. But if you'd like it to be, I can.
Well, that's okay.
No, okay.
Stick with unit of prosecution.
Does the statute speak to 2 different scenarios when it says wantonly or recklessly permits bodily injury, which suggests that maybe the focus should be on the injury, and then the statute goes on to say, or wantonly or recklessly permits another to commit an assault and battery, which focuses upon the act. Does the statute permit 2 different analyses of units of prosecution?
That would create, I think, some very difficult constitutional problems. First of all, it's hard to imagine, I can't imagine how anybody who permits someone to commit the assault and battery isn't also committing the injury to occur. So then you might be allowing the prosecutors the opportunity to charge, say, 5 versus 1 crimes based on their choice of which branch of the statute to go under. The one other point I'd make is that, again, going back to my analogy with the punch, the 2 injuries, what if, as a result of the force of the punch, my victim hits the ground and has a severe head injury?
Mm-hmm.
It's now a substantial rather than just bodily injury. Do we have 2 crimes? No more than we do in this case, Your Honor.
Or if the person dies, can you have a manslaughter and
No.
separately a violation of the statute?
No, I think that's very clear under our case law that if the same blow causes the 2, it's 1 crime. It's the manslaughter, and the assault and battery is subsumed within it. Unless the court has further questions, thank you very much.
Good morning, Kevin Curtin, Assistant District Attorney for Middlesex on behalf of the Commonwealth. And with me here today is Elizabeth Dunnigan, who is an Assistant District Attorney for Middlesex as well, and was the trial prosecutor. The unit of prosecution that the legislature intended in this Section 13J is based on the number of separate, statutorily enumerated injuries to a child.
And you say that, why?
Because that is the purpose of the statute, and the language of the statute tells us that.
How does the language tell you that?
Well, this is a different kind of statute from the kinds of statutes that we maybe are familiar with in the past, assault and battery. It's in response to a very specific need, and in the statute, the legislature, you can hear the legislature speaking in a different voice than that of the post facto, after the fact punishing of specific acts. That's not the language that the legislature is using. It's a voice that's based on that employs the language of responsibility, focused on preventing injury, and the responsibility that is going to be imposed on caregivers not to permit specific kinds of potentially devastating injuries.
Let me ask you this. If you had not the 3rd and 4th, paragraphs, but the 1st and 2nd paragraph, so it's the direct assault and battery.
Yes.
And you have evidence that there is an incident in which the caregiver did separate act, punched and whatever, and you had the result of the liver and the spleen, let's just say. Is that 2 assaults and battery, or is that 1 assault? It's all happening simultaneously, and it's under the 1st or the 2nd. That would be under the 2nd. Is that two indictments or 1?
If it were charged under this subsection, it could be 2. If it were charged under the assault and battery statute, it would be 1.
No, but I mean under the second
Under
paragraph of
the
this.
first theory of the actual infliction of each of those injuries.
Yeah,
could be 2.
Under 13JB, 2nd paragraph. Yes.
Yes, could be 2.
And if the crime is the failure to have the child seek medical attention when it was apparent that he needed it,
Yes.
do you then identify each of the ailments that the child had, and those are all separate crimes?
The condition, it could be more than 1.
Okay, but try my question. Let's assume a child has
yes.
multiple failures. Let's assume that the child may have many, many conditions, and the doctor could deconstruct it and find many, many conditions. Then the failure to act is then multiple crimes, even though the conduct is only the failure to seek medical attention.
The Commonwealth's position is yes.
And why does that make any sense at all?
Because the purpose of the statute is designed to protect children.
Of course, but I mean,
against
this
very
is designed, but we all agree it's designed to protect children, but you're saying something else. You're saying that it's designed to make it a separate and distinct crime for each injury, even though the crime speaks of failures to act as being the source of injury.
Failure to not act, Your Honor. Failure to prevent. And that's the difference.
How is that? How can you?
Because that is the difference. That's the difference of this kind of a statute.
Well, tell me what that means. Failure to prevent versus failure to act? How can you prevent without acting?
By not acting, you can fail to prevent. And by not, for instance, the Deborah Robinson case, which I know the court, Your Honor, is familiar with, where the child pierced her navel and as the result of that experienced a number of different injuries. If injuries have been specifically enumerated and the mother failed to act so as to cause her to experience those injuries, then each of those injuries are a separate unit of prosecution, because that's the difference in a statute like this. There's no proof.
But you keep
of
saying
action.
that, and Justice Botsford asked the question, and you say they spoke, but I'm looking at the statute, and I'm trying to find out, apart from the use of the term bodily injury, where they spoke. Is it just
Well,
that they say permits?
Look at the definition of bodily injury, Your Honor. It's at once specific, but it's also very broadly child-centered. We're talking about any burn, the fracture of any bone, subdural hematoma, quite specific, injury to any internal organ. These are all separately enumerated. Any injury that occurs as a result of repeated harm to any bodily function or organ. And
Doesn't
finally,
that just define the bodily injury, and doesn't the bodily injury itself modify the A and B? So that what you're really saying is it's not just any assault and battery, it's only those assaults and batteries that do have the consequence. But
no,
you're importing
that's not
in-
the Commonwealth's position, Your Honor.
I understand that. I just don't know how you got there.
It's because the bodily injury is separately defined. These injuries are separately enumerated and separately defined, and that's because it makes sense. You can't have a situation, these are for children, many of whom cannot report the occasions or the episodes of the abuse, the number of punches that occurred in each episode, for instance, or even the number of episodes or even the occasions. These are the children who are being protected here. This is the need that the legislature sees, and this is why the legislature had to craft a different kind of statute. This is not like a larceny statute or other.
How does the first or second paragraph compare to 13A, assault and battery?
Yes.
The language. How does it? I mean, I understand it's about a child, but is it the same language about commits an assault and battery shall be punished?
No, because it has to have, it's committing or permitting somebody else
Yeah.
to inflict specified injuries.
Bodily injury or substantial bodily. It doesn't specify the injuries. It just says
Bodily injury, and then those injuries are specified by definition, and that's the difference. That's the difference. One punch in the face that causes a cut to the lip and a chip to the tooth is going to be a single count of assault and battery. But an act, or the kind of wanton and reckless conduct intentionally engaged in, swinging a child around, throwing her up in the air, tossing him down onto the ground, that causes injury to the liver and to the spleen, that is two areas that are protected by the statute. Those are two, they're specifically enumerated. And the Commonwealth is permitted to charge accordingly.
Is there any other statute like this?
You know, I was thinking about that. There really aren't that, I'm not aware that there is one like this, because it's different. It's different, and there's a different need. It's important. You know, when we see things that are different, we worry about it. We're afraid of things. It's different. It's different.
Well,
I don't like that.
Is there anything comparable in other states? That,
You know, I did not research that. I wish that I had, Your Honor, but I know that that it's noted in Justice Dreben's opinion in the Garcia case, which is noted by Justice Berry in this case below, in the footnote.
Well, I guess, you know, because it is different, because, you know, you're saying there really isn't anything else that you can think of that's like this, and we don't really know about other states. I was wondering if there was also anything in the legislative history that would suggest that the legislature was really trying to do something different here and something specific here to protect children in a way that no other statute really addresses.
I think that there's an answer to that, and here's what it is. I think we know from Raposa and from the the concurrence in Raposa and in 1992 that this statute of 1993 was in response to that particular problem. We know that. It's in a published decision of the appeals court that teaches us that. And look at the way in which they responded. There's a need here. And in response to that challenge, In response to that challenge, the legislature did something different. They focused on the injuries because they know that occasions or episodes of abuse don't work when you're talking about children who can't report. And what we need to do, and this is what was wonderful and very accurate about Justice Barry's opinion in this case, when she says that these definitions, these separately enumerated areas of protection, are crafted to surround the child and to insulate against any such injury suffered while in the custody of a caretaker, whether inflicted deliberately or recklessly. She hits the nail right on the head there. And that's exactly what we know, because the legislature intended something different because they did something different here. It's different.
But it's kind of circular, don't you think? To say, we know that they intended something different because they did something different, and we know that they did something different because we know they intended something different, which is what I'm hearing you say. I mean, if the language itself is not making that clear, and we go to statutory intent, legislative intent, to determine what it is that the language means.
Right, and you look at the language, you look at the purpose of the statute, clearly to prevent injuries to children. In the language that they use, these definitions focused on injuries. It's just not conduct-based. It's not. It's not failing to act either. It's failing to prevent.
What's the statute about causing serious bodily injury?
That's part of this statute as well. And there are other separately enumerated conditions.
But I don't mean children. I mean just assault and battery that causes serious, I forget.
Drunk driving.
Oh, the aggravated assault and battery.
Yes, aggravated assault and battery.
Yes, that's different.
Why?
That's because that is an aggravating factor to the assault and battery statute. And it's not focused, it provides for,
It doesn't say whoever commits an assault and battery and causes serious bodily injury?
It's victim-based in that sense. But it's not victim-based in this sense.
And the language is very similar? Is the language very similar to the first or second paragraphs?
It's somewhat similar, but it's not so explicitly focused on the discrete injuries.
Where do you say this is focused on the discrete injuries?
They're separately enumerated in the definition.
I see bodily injury and substantial bodily injury, but that's true in serious. That's also true of serious bodily injury. It talks about disfigurement, et cetera, et cetera, et cetera.
That's true, but it's different because the focus is on any here, any burn, the fracture of any bone, not just either this or that or that. And so this is
the indictments specify the different injuries.
Yes.
Correct? Like one is liver, one is spleen, etc.
Correct. And there's no confusion about that. And so, this is different. This is a different kind of statute. It's certainly victim-based. We know this. But it's victim-based in a different way from, say, one shot killing a mother and the viable fetus. That's victim-based, certainly. But this is victim-based. It's focused on the injuries, not on the not the persons who are affected by the defendant's conduct. So
if a single strike or failing to stop a single strike that causes several different injuries could be charged in several different counts, right?
It could.
All right. So your brother says that just doesn't meet the Vic test unless the legislature has explicitly authorized. So you're saying the language here is explicit enough to authorize cumulative punishments?
Yes. We're talking about our concurrent violations of the same statute. This is not the Morey test. This is not the Vic issue. This is not cognate offenses such as indecent assault and battery and rape. It's just not. And so the issue is really about the unit of prosecution. And bearing in mind, this is, the thing that's different is we're talking about, Wolanski is very helpful. We're familiar with Wolanski, but applying it being used in this case, we're talking about a very high degree of recklessness that causes that kind of conduct has to be shown. That type of reckless or wanton or reckless conduct has to be shown. And if it results in these specific injuries, That's what is prohibited.
So how far do you go with this? So a person watches his wife strike a child in the chest, contusion of the skin, that's one injury. Rib damage, another injury. Damage to one or two organs, another injury. You can just basically deconstruct the crime and get as many crimes as you want.
Well, you got to prove them. You know, in this case, there were 13 fractured ribs that were different.
So each rib would be a separate injury.
We didn't do that. in
And
this
the
case.
contusion to the skin that no doubt resulted would also be a separate injury.
It is a separate injury, yes. And so, you know, these are things that the legislature has the power to do.
And if the legislature wanted to do that, why would they not have imposed a higher penalty than they did? 15 years for committing it, and wanton and reckless or causing it is
Pretty
2.5
high for each
if
one.
it's bodily injury, and if it's 5 years if it is
Well, one of the things,
substantial bodily injury. These sentences are not that high.
one of the reasons, perhaps, for that could be that I don't know if staircasing is the right word, but the fact is that on what we understand is appropriate in consecutive sentencing, that would allow a judge to impose consecutive
So the
sentences.
legislature said, we're going to impose relatively modest sentences because we are giving extraordinary authority to the Commonwealth to deconstruct the injuries and therefore do consecutive time. That's what the legislature meant to do?
It's not so much power to the Commonwealth, it's power to both the Commonwealth and the judiciary to address what the legislature has articulated as a special need. And the need is focused, Your Honor, on what I have said.
All right, thank you.